Mr. Jacob.
Yes. So, I think we're starting at 2. I believe, I'm speaking to my own friend, I have 1 hour, 25 minutes left. So by 3:25, if not before, I'll sit down.
Good.
So, we now come to the issue raised by the respondent's notice, logically the first issue in time, as to whether Miss O'Connor was actually a qualifying tenant at all. And this is dealt with in the Upper Tribunal judgment, so core bundle, page 73, paragraphs 69 to 70. Accordingly, I find that where a flat is let on an equitable lease and there is no legal lease of the flat, the lessee is the qualifying tenant if the statutory definition of a long lease is met. For the avoidance of doubt, I repeat, where there is both a legal and an equitable long lease, the legal lessee is the qualifying tenant. And therefore, at 70, the conclusion was that Miss O'Connor was a qualifying tenant because she had the equitable lease, the first lease granted of her flat. So this really depends on the proper interpretation of section 75(2) of the statute. The authorities bundle, page 11. Subject as follows: a person is the qualifying tenant of a flat if he is tenant of the flat under a long lease. And then section 76. My own friend referred you to a number of types of long lease as defined in section 76(2) on page 13. So we have 6 items there. A, as my own friend explained, is common ground. A is likely to be by far the most that one would ever see, the over 21 years term of years. And in fact, all the others, B to F, were described by yourself, my lord, in the Canary Gateways Court of Appeal case that my own friend referred to. We don't have it in the bundle, it's referred to in a footnote to the respondent's skeleton, footnote 6. And the way you described these other categories, my lord, is they were circumstances uniformly likely to occur infrequently, if at all. So that does need to be borne in mind, that all these other items are really outliers. Primarily, we will be concerned with section 76(2)A type tenancies. It's true that there may be some legal tenancies within this list which cannot be identified on the register. One in particular is E, the shared ownership lease, whether granted pursuant to part of the Housing Act 1985 or otherwise, where the tenant's total share is 100%. And that's been held to include short leases, so it could include a lease of less than a 7-year term, so it would be incapable of registration. The other key provision, which you've already been taken to, section 112(2), that appears on page 70, authorities bundle. In this chapter, lease and tenancy have the same meaning, and both expressions include, and then these words in brackets, where the context permits, and then it has a number of options. It's worth noting these words do not always appear in statutes that have these wordings. You don't have some other statutory provisions here. They were before the Upper Tribunal, and Judge Cooke refers to some of them. Paragraph 43 of her decision, which is core bundle, page 69. She refers to ones that I cited to her there. So there's the Landlord and Tenant Act 1985, section 36, Landlord and Tenant Act 1987, section 59, and the Housing Act 1996, section 229. All of those other statutory provisions have the same wording, save that they do not have the words where the context permits added in brackets. So there's some distinction being made between this statutory scheme and those other statutory schemes as to when this extended definition of lease and tenancy will apply. So the key is determining what is a tenant under a flat of long lease with the meaning of section 75(2). The starting point, I say, is what is the natural meaning of these words. In my submission, the natural meaning, as the starting point, is a tenant as a matter of law. And I rely on Court of Appeal decision at tab 8 of the bundle of 159 to 167 Prince of Wales Road, RTM Company Limited and Appellant Limited. Case in which both Mr. Bates and Miss Gibson were involved. And there, the respondent asset hold had purchased a freehold subject to a lease. It was unregistered at the time of service of the claim notice. It served a counter notice objecting to the acquisition of the right to manage, and the application went before the First Tier Tribunal for determination. That was then withdrawn by consent, and another argument arose out of that, which was that the respondent asset hold sought costs under Section 88. You may recall that was referred to earlier. So a landlord can receive costs of dealing with a claim notice served by a right to manage company. And then if we go to paragraph 27 on page 116 of the bundle, the authorities bundle, it set out Mr. Bates's case. So asset hold's case is that the buyer of a property in the registration gap between completion of a purchase and its registration at the land registry is a landlord for the purposes of section 79(6) and the cost provisions in section 88. And he talks about equitable ownership having passed despite the fact there was a lack of registration. And at paragraph 28, I rely on this. So I do not agree that an equitable owner can be a landlord for the purposes of section 79(6) and 88 of the CLRA. In its ordinary and natural meaning, a landlord under a lease means the landlord as a matter of law. And all I take from this is that I say is the ordinary and natural meaning of a landlord under a lease is the landlord at law. It's equally applicable, I say, in deciding the ordinary and natural meaning of tenant under a long lease in this statute. The natural reading would be that that means a tenant as a matter of law. This can be contrasted with another statute if we turn to tab 4 of the authorities bundle. There you should see the Leaseholder Reform Act 1967, section 37, which deals with interpretation. So this is dealing with tenants of houses who wish to purchase the freehold or extend the lease of the house. If we go over the page to page 96, subpara F says tenancy means a tenancy in law or in equity, then continues with some exclusions. So I say if Parliament wishes to incorporate tenancies in equity, it does so expressly, in this case by adding that into the definition. And it does so because the natural meaning is that it's the tenant at law. Now, Judge Cooke did not accept this. So if I could take you back to the core bundle, page 71. So paragraph 54 on page 71, she explained that she did not agree with me that the natural reading of the provision is that it refers to legal, not equitable leases. She explained how a lawyer could regard either a legal or equitable lease as a lease, explained her reasoning there. She then rejected my reliance on section 37(1)(f) in paragraph 55, did not regard the absence of an express provision such as the one in section 37(1)(f) of the Leasehold Reform Act 1967 for the inclusion of equitable leases or a tenancy in equity as a problematic in view of the presence of section 1122, which expressly includes an agreement for a lease or tenancy. So she seems to regard that section as supporting her reasoning that it should include, well, that the natural reading includes equitable lessees. And my distinction between that statute and the other statute is not assisting me. In my submission, the existence of section 1122 actually supports the construction that a lease only means a legal lease as a starting point. Because if we consider the position if the natural meaning includes an equitable my submission is as follows. So if we look at section 75.2 and we say that naturally means legal or equitable lease, equitable leases include agreements for leases which are capable of specific performance. An agreement for a lease capable of specific performance will take effect as an equitable lease. So if that's right, if section 75.2 already naturally incorporates equitable leases, what does section 1122 add to this? So just to remind ourselves that that incorporates where the context permits, section 1122B on page 70 of the Hoist Bundle, an agreement for a lease or tenancy, or for a sublease or a subtenancy. So if it's adding on agreements for lease, what is it adding? If the lease is already incorporating equitable leases, it already incorporates agreements for leases which can be specifically performed and therefore take effect as an equitable lease. The only thing it can really add where the context permits would be, in my submission, an agreement for a lease which is incapable of specific performance, which would therefore not take effect as an equitable lease.
If we bear in mind that this statute is aimed at to be as simple as possible for ordinary people to understand, references to specific performance and so forth are not going to cut much ice, are they? So, I mean, I can see this argument saying it's just put in for the, maybe, possibly, and for the avoidance of doubt, but certainly to avoid the need for further inquiry on a point which arises quite often.
Well,
is there any force in that kind of argument, do you think? Or not? If not, why not?
Sorry, that one can't consider it in this granular detail because it's supposed to be...
Well, I'm not saying you can't, but I'm just wondering ultimately how far it's going to get us. And also, given the emphasis on simplicity and the material we've been taken to about the general purpose of the legislation, one might perhaps be more receptive to a degree of possibly of unnecessary explanation or inclusion of something that wouldn't necessarily have to be spelled out.
Well, if one wanted to include things to make it clear to the layperson who doesn't understand the complexities of the law, then one could say lease in law or in equity. That yes. Formulation, for instance, could be added, but that hasn't been added. So
I take your point that language would have made the point very simply. Yes.
Yes. Yeah. Given they don't do that, I say adding this, if already the natural meaning to the layperson is that the lease includes equitable and legal, all this can add is an agreement for a lease which is incapable of specific performance, because that's the only type that wouldn't take effect as an equitable lease.
The trouble is it produces such odd results. So if you contract to take a lease, you've got an agreement for a lease, you're a qualifying tenant. At the point at which you're actually granted a lease, until it's registered, you're not a qualifying tenant. And that's even though you've got a lease. It just happens that it doesn't take effect at law, but you say, look, I bought the lease, I'm living there.
Well, I say also the context does not permit an agreement for a lease to result in a qualifying tenant. I say the only qualifying tenants are those with a legal lease, because of the context of this scheme, that it needs to be a simple scheme. If one allows either equitable lessees or those with agreements for a lease, or both, to come into the definition of qualifying tenant, then the scheme starts to become unworkable to the lay people who are supposed to be able to operate it simply. And there are various ways in which I can seek to demonstrate how it becomes unworkable.
The trouble is, the layperson is then very much misled. They look at the act, they see agreement for lease counts, and it turns out it doesn't.
Well, where the context permits, but that they need to try and work out what that means. It's always difficult to tell in terms of the layperson being able to understand a statute, because they probably can't understand any statute.
No,
it's all a theoretical concept that we are dealing with
yes.
here, as it happens. The civil procedure rules, again, another thing that I doubt any layperson can really understand, despite the fact that the courts expect them to be able to understand it.
And when one sees applications by litigants in person deploying provisions of the civil procedure rules or whatever, one realises that these problems arise.
And if it was so simple, why would the white book have so many notes and be so big? So, but I still say that ultimately, the need that Parliament saw to put this in supports my argument that lease wouldn't naturally incorporate an actual lease. So to the extent that this is adding something, it supports the conclusion that there's nothing beyond legal lease as a starting point. It really comes down to, in my submission, whether the context permits one to add actual leases and or agreements for leases to the definition of a qualifying tenant. Part of the context is the general nature of the scheme, as we've just discussed, about it being as simple as possible. The procedure should be as simple as possible to avoid the kind of obstruction that Mr. Bates and Ms. Gibson's client is seeking to employ here. Now, part of what we rely on is an aspect of the construction against absurdity. We've got some provisions of Benyon in the authorities bundle. That is tab 29. I don't propose to take your lordship through it all in detail. You're well aware of it, but it goes beyond, of course, mere absurdity. It has various aspects to it. So it's a legitimate exercise in interpretation to avoid an unworkable or impractical result. It's potentially, depending on the circumstances, a legitimate exercise in construction to avoid an inconvenient result. Only one aspect of this I'd just like briefly to refer your lordships to is on page 461 of the authorities bundle. At the bottom of page 461, it has a heading, definitions expressed to apply unless the contrary intention appears. It's slightly different wording, but it says, where an act provides for a statutory definition to apply unless the contrary intention appears, the fact that the statutory definition would be unworkable or otherwise absurd in a particular context is likely to be a clear indication of contrary intention. Similarly, when deciding whether the context permits, if it results in an unworkable, impractical result, in my submission, you would be entitled, as a matter of interpretation, to avoid that impractical, unworkable result by saying the context does not permit in this case. Now, Judge Cooke accepted that effectively, that the presumption against absurdity works to some extent on page 72 of the core bundle, paragraph 58. Well, in fact, she went beyond that and said she didn't even need to rely on the construction against absurdity. In my judgment, that is not an available construction. So, sorry, she's just referring back to when there's a legal lease and an actual lease. And can it be right in these circumstances the actual lessee is the qualifying tenant? So, below, the argument on the other side was that it's always the actual tenant who's qualifying lessee, even if there's a legal tenant. That she rejected. In my judgment, that is not an available construction of statute. It's a matter of plain common sense, let alone the principle of construction against absurdity. It would make the acquisition of the right to manage well nigh impossible. And she explains why. So she accepted it to a certain extent, an aspect of what I'm arguing, although she says it's plain common sense rather than even relying on the presumption. Yeah. She rejected it when we get to the situation that we're dealing with here, and that's paragraphs 63 to 64. And then, as my learned friend mentioned to you earlier, so she came up with two scenarios. So either the actual lessee is a qualifying tenant or there's no qualifying tenant. The need to construe against absurdity rules out the reading of section 75 that takes the qualifying tenant to be the actual lessee where a legal and actual lessee coexist in different hands. But does it rule out the actual lessee where there's no legal lessee? She rejected this at paragraph 64. She said the fact is not visible on the land registry is not fatal to their inclusion because some of the legal lessees within the definition of section 76 are equally hard to discover. That I accept. Some are set out in section 76.2. Then she gives another example of when the legal estate passes to the personal representatives of the deceased tenant. She also makes a point that I think you were taken to earlier by Mr. Bates as well. Paragraph 68 on page 73. Around 5 lines down, there's a line starting with register. She says, and second, because such tenants will in many cases be readily discoverable because they live at the property, as does Miss O'Connor, and may even be in touch with the RTM company, as Miss O'Connor was in this case. So, in respect of sorry, just bear with me a second. In respect of this point as to them being readily discoverable, that's not necessarily the case. In this case it may be, but there are lots of cases where there's a block of flats and they are let on long leases to foreign investors. That's a scheme that's cropped up, and I've dealt with a case along those lines. I'm sure Mr. Bates has dealt with a number. So you can have a situation where the qualifying tenant will be abroad. Their flat in the premises may well be let on an assured short tenancy to somebody as part of a scheme to make money, investment type scheme. There's no residence requirement in this statute, unlike other statutes in the 1993 Act. So when you have a scheme where the tenant does not need to be present, where we know in practical terms that you do have foreign investors, it's not so simple to say, well, you'll probably be able to find out who they are. Maybe in some cases, but in a lot of cases not.
Could one make the same point about domestic buyers who want a kind of buy-to-let investment, or would that really be ruled out by the covenants and the leases, or would it just all depend?
Might depend on the leases, but yes.
Yes.
I mean, there is no residence requirement, so they
No,
can do
exactly.
whatever
I
they
was
want.
thinking somebody who buys it with the object of
Yes.
letting it off at a rack rent to short-term subtenants.
Subject to the terms of the lease, they
Subject
can
to
do that.
terms
Yes.
of the lease, yeah.
So even somebody who's not abroad, they could still be in the country. They may be difficult to find. You wouldn't necessarily know what's going on in that flat.
Yeah.
You might just see a tenant on an assured tenancy. You'll think, well, they're not a qualifying tenant, are they? So we don't need to worry about them. As regards other long leases as defined in Section 76 being off register, yes, potentially they are, but they are very much outlier cases, and also they can all they're all capable of taking effect at law. The scheme can still work if one restricts it to legal tenancies, merely because that creates some outlier legal tenancies which are difficult to find. Does not, in my submission, justifying bringing in a whole raft of unidentifiable, potentially unregistered interests when looking at the key provision, the majority provision, the Section 76(2)(a) type of long lease.
Just in terms of numbers, on the judge's decision, you're only dealing with new leases, aren't you?
Yes, so a flat with the first grant of a long lease.
Yes. So it's only going to rise when you've got a new building or a new organisation of a building in practice.
It will mainly arise when you have a new building and you're letting it off, but it could in theory arise where the freeholder retains some flats for whatever reason, hasn't let them off, and later they, at some stage, months or years later, they let off another flat.
Yes.
So yes, in theory it could apply any time. But it can get quite difficult when you have larger blocks. So this block didn't have a huge amount of tenants, but you do get blocks with 100 flats, with even 1,000 flats. The more you have, the more potential there is for qualifying tenants to be missed off if equitable leases constitute a qualifying lease and a qualifying tenant. So, and again, this is supposed to be a simple procedure. The RTM company is supposed to be able to relatively easily, one would expect, ascertain who are the qualifying tenants they need to serve the NIPs on. But we end up in a situation, if you're dealing with equitable leases and even agreements for leases, so somebody may not be with their lease pending registration. That in this case, there was a note on the register of something was pending, unknown to the right to manage company exactly what it was. But if we interpret this as we understand Judge Cooke is interpreting it, then even the agreement for a lease will create the qualifying tenant. So they just need to enter that agreement, not even get to completion of the lease itself. This is going to create, if this is the correct interpretation, it creates qualifying tenants about whose existence the right to manage company would just have no idea. Judge Cooke even recognised that there may be cases, as she was dealing with the party submission, there may be cases where it's effectively impossible to identify these qualifying tenants. Now, one potential response that the appellant may say is there's a right to information, section 82 of the statute. So that's Authorities Bundle, page 25. (82.1) A company which is a RTM company in relation to its premises may give to any person a notice requiring him to provide the company with any information, A, which is in his possession or control, and B, which the company reasonably requires for ascertaining the particulars required by virtue of Section 80, including the claim notice, for claiming to acquire the right to manage. So there's potential for the right to manage company to start making inquiries. But that isn't a complete answer, and this was dealt with in a slightly different context by the Supreme Court in A1 Properties, when a similar argument was made on behalf of the landlord there. So that's, if we can go to tab 10, page 182. You should see paragraph 99, where the C is, down the left-hand side of the page. It says whether there are intermediate landlords. After that it says, although Section 82.1 gives a right to an RTM company to obtain certain information, that does not meet the point. The company may be unaware that there is anyone about whom they should be asking for information. The fact that a RTM company has a chance to start again does not undermine these basic considerations. And I say, if one adopts Judge Cooke's analysis, then you result in a similar situation. There may be people they simply don't know who they're supposed to make inquiries about.
And you say, well, they could be abroad anyway, and then it's rather difficult to
yes.
operate Section 82.
But if we restrict this to legal tenants, it's a relatively easy procedure, so far as the vast majority is concerned, the Section 76(2)A long lessees, who will have to have registration to become the legal tenant. Then one can check the register. If not, and we incorporate actual tenants and those with agreements for leases, then we have a situation in my submission where the right to manage company has to make speculative Section 82 inquiries on the off chance that something might crop up. Because if they don't, they may meet the obstructive landlord who takes this point later down the line. So it starts to become quite a cumbersome procedure in my submission. They can search the register of title, find out what's there already. Then if they ascertain there may be scope for some other off-register long lease, they can make the Section 82 inquiry under the procedure that I've shown you. The landlord has 28 days to respond to such an inquiry. But if one faces an obstructive landlord, it's quite possible they simply won't respond. The statute deals with this in Section 107. So if we go to tab 1 of the Authorities Bundle on page 62, there is a power of the appropriate tribunal, First Tier Tribunal, to order compliance. So Section 107.1, the appropriate tribunal may, on the application of any person interested, make an order requiring a person who has failed to comply with a requirement imposed on him by, under, or by virtue of any provision of this chapter to make good the default within such time as is specified in the order. But there are preconditions in subsection 2, so you can't make the application unless you've served a notice on the person requiring them to make good the default and not more than 14 days have elapsed since the expiry. So this is potentially the sort of procedure the right to manage company may go down with an obstructive landlord to try and get this information. Now, once they've got any response to the Section 82 inquiries, it can be quite a cumbersome procedure to actually arrange for service of all the NIPs. So if you have a block of flats with hundreds of flats, or even going into thousands of flats, it can actually take administratively more than one day to prepare all these documents and send them out. If all the freeholder potentially needs to do is enter into an agreement with a lease to create a new qualifying tenant, even after they send back their Section 82 inquiry, they can the next day immediately enter into an agreement for a lease, creating a new qualifying tenant as a way of obstructing this process.
There have to be a spare flat.
Yes, but if there is, this scenario can arise. It is, well, I can't say it's frequent, but freeholders do sometimes keep flats within their own, just on the freehold, and don't let them out. They keep it for themselves. A landlord who wanted in future to prevent the right to manage might keep one handy for this sort of procedure. We are dealing with the obstructive type of landlord. This is the sort of scenario that I'm envisaging here, rather than just your average landlord where this wouldn't crop up. A further point to the analysis, which I don't think the Upper Tribunal has dealt with, is what if there are a chain of equitable tenancies? So, what if the freeholder grants a 250-year lease? It's unregistered at this point, so it remains equitable. But the tenant under that, before registration, grants their own lease to a subtenant, 249 years, say. So again, that's unregistered, again equitable. We have two equitable lessees. Who's the qualifying tenant there? Well, the statute would suggest there's an answer in section 75, 5 to 6. So if we can go to tab 1 of the authorities bundle, page 11. May recall Mr. Bates took you to this. So page 11, section 75, 5. No flat has more than one qualifying tenant at any one time, and subsections 6 and 7 apply accordingly. 6. Where a flat is being let under 2 or more long leases, the tenant under any of those leases which is superior to that held by another is not the qualifying tenant of the flat. So that would suggest if we do incorporate equitable lessees, it would be the lower of the two in the rung who is the qualifying tenant, even less discoverable than the one higher up. So if the RTM company makes an inquiry as to have you granted any leases, haven't yet been registered, and they get a response saying, yes, we have of this flat, what do they do then? Do they make a further inquiry? And if they don't, are they then stuck with the fact that there may actually be a second lessee down the chain of equitable lessees who comes into this definition? So again, I say this supports the conclusion it should be legal and not equitable lessees in order to try and maintain some semblance of simplicity in this procedure. I also say that some of the analysis of the Supreme Court and Tudor Studios assists in this. Although they're considering a different question, some of the analysis helps us to work out how they viewed the process of identifying landlords and qualifying tenants. So if I could take you to the authorities bundle at tab 10. Within that, if we go to page 176, we have paragraph 72 redlined. So they say, by contrast with qualifying tenants, Parliament clearly did appreciate that there might be difficulties in finding or identifying relevant landlords or other stakeholders as recipients of claim notices under section 79.6, no doubt for the reasons given at the beginning of this judgment. There will be no ready list of them, and the registered title of the freehold and leasehold interest in the building may not reveal them all. Careful provision was made to deal with the problems which might be caused for implementing the RTM scheme. So they're contrasting qualifying tenants and landlords. In the case of landlords, they identified that Parliament had created some exceptions and exclusions for not having to serve unidentifiable landlords. But it didn't with qualifying tenants. And the reasoning, they draw this contrast between landlords and tenants and the registered title. So if we restrict qualifying tenants to legal tenants, the vast majority of them will be on the title register. That would explain why Parliament did not have any kind of carve-out for failing to serve a particular qualifying tenant who couldn't be identified, perhaps because they're a sub-equitable lessee. But this analysis of theirs, the distinction they're drawing, doesn't really work if actually equitable lessees off register can be qualifying tenants. Why wouldn't Parliament try and deal with the unidentified, unidentifiable qualifying tenants in those circumstances? Whilst I acknowledge there will be some rare instances of off-register legal qualifying tenants, that doesn't mean that one should interpret the statute so that there will be potentially a huge number of off-register qualifying tenants appearing. The statute can perhaps deal with some modest difficulty to enable legal tenants to assert their rights, but not huge difficulty to enable equitable tenants to assert their potential rights. I could take you a bit further in this judgment from the Supreme Court to page 182. So there's just a part in paragraph 99 which the appellant relies on. So 99, they say these issues are serious concern generally. So they're talking about opportunities for obstructive landlords to thwart the scheme and procedural requirements. Well, in fact, I refer you to paragraph 98 as well in support of my argument. But first, the purpose of the legislative scheme, as explained in the consultation paper, includes the objective that opportunities for obstructive landlords to thwart the transfer of the right to manage should be kept to a minimum. The procedural requirements have not been included to create traps for the unwary, nor to afford unwarranted opportunities for obstruction on the part of objecting landlords who have not themselves been significantly affected by any particular omission to comply with them. These issues are of serious concern generally, and especially so given there is no register of relevant landlords on whom a claim notice should be served. As explained above, these include landlords under short-term leases which will not appear on the register or in any other accessible record. A relevant lease does not even have to be written. And there they refer to section 1122. How the appellants rely on this, I can just remind myself of what they say. In their skeleton, core bundle, paragraph 50, page 55, paragraph 22, they say, moreover, the Supreme Court in A1 Properties at 99 recognises that a relevant lease does not even have to be written and gives section 1122 as authority. The court cannot be referencing agreements for leases here because such an agreement must be in writing. Section 2 of the Law of Property Miscellaneous Provisions Act 1989, Empton Farrell extract is cited. The court must instead be referencing other leases which are leases within the 2002 Act by virtue of section 1122B, but not because they are agreements for lease. This supports a broader interpretation of section 1122 and 75 than that submitted by the respondent, as recognised by the Upper Tribunal at 50C70. Just to go to 50C70 to see what that's about. So on page 70 of the core bundle, there's paragraph 50 of Judge Cooke's judgment. She says, Mr. Bates, King's Counsel, in response, stressed that the Supreme Court in A1 Sunderland was not making a decision about qualifying tenants, and anything it said about them is obiter. However, its reference to section 112 makes it clear that the Supreme Court was aware that a lease in section 75 includes an equitable lease. Now, it's not clear whether she's just reciting his submission or actually agreeing with what he's saying now. It seems perhaps it's just reciting what he was saying at that stage because she was setting out his arguments before she got to discussion later. But in my submission, that doesn't work. What the Supreme Court said does not support the conclusion that a lease in section 75 includes an equitable lease. What the court are doing, the Supreme Court in A1 Properties, is something rather more simple. They're just saying a relevant lease does not even have to be written, section 1122. If you look at section 1122, it doesn't say a lease has to be written. It says lots of other things, but it doesn't impose a requirement that a lease must be in writing. That's all they're noting there, nothing more, nothing less.
So what sort of lease have they got? What sort of agreement for a lease have they got in mind?
Sorry, they're not talking about agreements for leases, they're talking about a relevant lease does not have to be written. So you could have a lease of 3 years or less taking effect in possession at the best rate, rent obtainable without a fine. That could be a legal lease without being in writing. It could be oral.
Yes.
Section 54, subsection 2 of the 1925 Law of Property Act. So they're saying that a lease doesn't have to be in writing, so it's difficult to identify landlords to serve claim notices because it is very different the way that it works. That a qualifying tenant is a tenant under a long lease as defined who you need to serve a NIP on. A landlord is not a landlord under a long lease so defined, it's just a landlord.
Yes. And
a landlord does not, their lease doesn't have to be in writing to make them a landlord. So it's different schemes. That's all they're noting. That doesn't get any support for the argument that, oh, that means a lease must be an equitable lease. That's not what they're saying at all. They're just saying a legal lease doesn't have to be in writing.
yeah.
The argument that it's only the legal tenants who are qualifying tenants, I say, is also consistent with the analysis of Mr. Justice Fancourt in the Upper Tribunal in the Canary Gateway case. So if we go to tab 14 of the authorities bundle, page 251, So paragraph 87 on page 251. He says, it is therefore very easy for the RTM company to serve each qualifying tenant and to identify them, since in virtually all cases the qualifying tenants will be long lessees. Their interests will be identifiable at the land registry. So, as part of his analysis for why he says there is a clear consequence of failing to serve a qualifying tenant, you have to start again. Part of it is to say, well, actually, it will be relatively easy to find these qualifying tenants because they'll be identifiable from the land registry. Now, although it may not have been argued this particular point before him, he seems to be assuming that the long leases in section 762A, the over 21 years, will be registered, and therefore that's what you're dealing with. He's not accounting for the potential for there to be unregistered equitable long leases, or indeed mere agreements for long leases that haven't even got around to the stage of completion to grant the lease itself. And his reasoning may have actually resulted in a different conclusion if he did take that into account. Because if we go a bit back in his analysis, just bear with me a second. So in paragraph 83 on page 250, this Mr. Bates, I think, quoted to you. So he was talking about what the purpose of section 792 might be. He gave the two options, either it's to give the time period or it's to give the consequence of failing to serve, or both. He explains at the bottom of 83, this is an issue of interpretation that requires context and implication for the provision to be taken into account in construing it. 84, it is therefore material to consider as part of the exercise of statutory interpretation the objective importance of the statutory scheme of notices of invitation to participate being given to every qualifying tenant, the relative ease or difficulty of compliance, among other matters. So one of his points is how easy or difficult is it to comply when deciding whether Parliament was giving you a consequence of invalidity of failure to serve one. And part of his reasoning for finding that it was Parliament's intention for there to be invalidity was paragraph 87, the ease of identifying qualifying tenants, the majority of which would be on the register. So this goes back to a point I said earlier where there may be some interplay or crossover between the two issues, that if you find Miss O'Connor is a qualifying tenant, perhaps you'll be more receptive to the argument it can't be total invalidity in all cases because there will be unidentifiable qualifying tenants out there that will scupper a scheme. Alternatively, if you view the consequence as being a bright line rule that there must be invalidity, that would support my argument that therefore equitable lessees and those with agreements for release should not come into the definition of a qualifying tenant because there'll be too many tripwires and the scheme will be invalidated too often.
Just while it's in my mind, going off on another tangent for a moment. So the definition of lease is section 1122.
Yes.
And that is a definition that works for the part for the purposes of the right to manage. Chapter 1.
Yes.
Of part 2.
Yes. So it covers.
So can one identify other places where lease should mean agreement for a lease? Taking it that you say, well, it doesn't mean that in the context that we've been looking at.
I don't have one for your lordships. It may or may not be possible, but I don't have one to give your lordships. All I can say is that it says where the context permits. It envisages that it will not be all cases. In some parts of the statute, it won't mean it. In some parts, it will. We know, as I highlighted earlier, that in other statutes, those words have been omitted. So there was a point for Parliament to put that specific reference to context in here to mean that you need to work out when in the statute we do have this extended definition and when we don't. And although I can't provide examples of when you might have the extended definition, I can submit that this is not the right case for there to be the extended definition in my submission.
Yep.
I'd like to address briefly some points made by my learned friends in their submission. So if we go to the core bundle, page 54, paragraph 17, they say that the Upper Tribunal's decision is consistent with other case law and statutory provisions affording powers and rights to equitable lessors and lessees. There are 4 examples given there. I'd just like to quickly go through those. So, equitable business tenancies protected under the 1954 Act. There's a reference to section 23 and section 69 there. Now, my response to this is simply to say that section 69 is a very different statutory provision, and so it needs to be interpreted on its own terms. You will find it in the authorities bundle at tab 5. Section 69 is the interpretation section of the 1954 Act. Over the page, on page 100, you'll see the definition of tenancy. There it has an extended definition of tenancy, which does not appear to contain any reference to the context permitting. It's simply a definition without that. And it's an extended definition with various aspects to it. So all I say is that, yes, on the terms of that particular provision with totally different wording and without reference to context, maybe that's the case, but it's irrelevant to consideration of our scheme and our statutory provision. The next one in their list, paragraph 17b, an equitable assignee in whom no legal estate is vested because the transfer has not been registered is nonetheless entitled to apply for relief from forfeiture under section 146 of the Law of Property Act 1925. Section 146 you'll find at tab 6 of the authorities, but you'll find it. Yes, tab 6 of the authorities bundle on page 104. The reason why an equitable assignee is entitled to apply for relief from forfeiture prior to registration appears to be based on subsection 5, starting at the bottom of 104 and going over the page. Subsection 5a. So for the purpose of this section, A, lease includes an original or derivative underlease, also an agreement for a lease where the lessee has become entitled to have his lease granted, also a grant for a fee farm rent or securing a rent by condition. The reason why I say that's the relevant provision is it appears to be explained in the authority that's referred to in the Woodfall Landlord Tenant Extract we have. So again, it's a specific statutory provision. It works on its own terms. It doesn't really assist us in this case.
It'd certainly be pretty bad if you couldn't apply for relief from forfeiture in such a case.
Perhaps so, but one has a statute dealing with that scenario. We have a different statute dealing with our scenario.
Yeah.
The next one in the list. Split. Well, I do see is a point about equitable owners in a registration gap being entitled to exercise owners' powers. That might be the case, but it doesn't really tell you what a qualifying tenant is in this statute. D makes reference to Scribes West Limited and Relsa Anstalk number 3, Court of Appeal case. A registered freeholder has assigned the reversion on a lease. The assignee of the reversion was entitled to forfeit the lease by peaceable re-entry, even though it had not yet been registered as proprietor of the freehold. The automatic passing of the rents under section 1411 of the Law of Property Act 1925 operated in favour of an equitable assignees and not just in favour of a transferee who had registered its transfer at HMR by virtue of section 1412 1925 Act. This all again comes down to some statutory interpretation of a different statute. This is back to the authorities bundle tab 6, a prior page, page 102. Section 1412 says any such rent, covenant or provision shall be capable of being recovered, received, enforced and taken advantage of by the person from time to time entitled, subject to the terms, the income of the whole or any part, as the case may require of the land leased. And this, if one looks at the Scribes West case, all came down to the meaning of entitled and who was entitled to the income. If you're entitled to the income, you came under the statutory provision. Again, it's a different statute, different wording, different explanation. at paragraph 14 of the respondent skeleton, law bundle page 53, paragraph 14, they rely on an Upper Tribunal case, another one of Judge Cooke, I believe, RM Residential Limited and West Acre Estates Limited, and that talks about the registration gap as part of the analysis there. And they rely on that as saying in that case the actual owner was entitled to serve statutory notices and make applications in accordance with statutory rights. I'm reading from paragraph 15 of their skeleton. They were the owner in all meaningful senses, and those rights were not lost or held in abeyance while waiting for the administrative process of the land registry to work their way through to registration. Now, I say this case again doesn't assist them. So, in the RM residential case, the appellant purchased the freehold of a property, carried out some works to the property. They hadn't consulted to enable them to claim the value of the works and the service charge from the tenants. So they applied for dispensation from the consultation requirements so they could claim the service charges for the works they carried out. And it was argued on the other side that they couldn't carry out these works pending their registration as freehold owner, so they weren't entitled to do the work, so how could they try and claim them the service charge? This authority you'll see at tab 23 of the authorities bundle. If we go to page 403, it was an appeal from the First Tier Tribunal's decision. So actually 402 at the bottom, 402 paragraph 35 at the bottom, you'll see Judge Cooke said the FTT said, and she then quotes from their decision. If we go over the page to 403 paragraph 18 from the quotation, it appears therefore that the applicant had no locus standi either to do the works or to make a section 20ZA application, that's the dispensation application, prior to their registration of title on 7th of January 2022, by which time the works have been completed. And then they note the date of the application. So the FTT, when they came to reject the application, they did so on the basis of no locus standi to do the works and no locus standi to make the application. The Upper Tribunal, paragraph 39 to 43, deals with entitlement to do the work. 39 talks about the legal title being held on bare trust for the purchaser during the registration gap, the vendor having no power to make decisions about the property and acting on the direction of the purchaser. Quotes section 24 of the Land Registration Act. 41, she talks about the practical effect of this when you buy a house. On completion, the transfer is signed and dated, the keys are handed over and the purchaser moves. Property belongs in equity to the purchaser, and to say at that stage it is not the owner of the property both flies in the face of everyday reality and betrays a failure to understand equitable ownership. And what she does, following on from that, then going down to paragraph 43, she ultimately concludes, so the appellant's right to take possession of the property and carry out the work cannot be in doubt. So she's dealing with whether they have entitlement to carry out works pending registration, and she concludes they are. Then paragraph 44, turning to ground 2, equally there can be no doubt about it standing to apply for dispensation under section 27A of the 1985 Act. And then she refers to section 30 of the Act. She's going through the 1985 Act and to the wording of that Act as to section 27A and section 30 and to who can be entitled to make an application. This is all based on another statutory scheme and her interpretation of that statutory scheme. That scheme, that Act, the 1985 Act, contains one of the identically worded provisions to section 112 that we're dealing with in this Act. So there's section 112 here about where the context permits. This is a statute you're dealing with here, which is one where it has the identical wording, but just the words where the context permits are taken out. So there's a difference in the extended definition of lease in that statute, and she's interpreting Section 27A, Section 30, she's interpreting different statutory provisions to try and reach the conclusion in that case. So simply because in that case she found that an equitable owner could do certain things to the property and was entitled to seek dispensation, doesn't really assist you in working out whether the context permits an equitable lessee to be a qualifying tenant in the right to manage legislation. I'd also ask you to note that she did, even in this, she recognised there were some things an equitable owner cannot do. At the bottom of paragraph 41 on page 403, the last sentence, true, there are just a few things the equitable owner cannot do in the registration gap, such as giving notice to quit. So there's a recognition that the common law, there are some things they can't do, and I say in this statutory scheme there are other things they can't be. They cannot be a qualifying tenant because they are equitable. And I say none of these authorities or statutory provisions that my learned friends rely on assist. They're all distinguishable on their own facts, their own schemes. Another argument that is made against us is to say that interpreting the statutes in the way that we suggest is depriving some tenants of their rights. So it's taking out some equitable tenants pending registration of their rights. And it said this is inconsistent with the policy of the legislation. I think at some stage it's been rhetorically asked on the other side, well, what's the legislative purpose or policy furthered by excluding them? And I say the policy or purpose furthered is keeping it simple, effectively. This is supposed to be a simple procedure to avoid traps for the unwary, avoid obstruction. So even if the result is that some equitable lessees don't get the benefit of this scheme, the flip side is it is kept more simple for the ones who are on the register, for the legal tenants. They are able to exercise their right and they don't have to face the sort of obstruction that we end up with in this scenario. So, the ultimate conclusion is the context does not permit equitable lessees or agreements for release to be brought into the definition in section 25(2) of a qualifying tenant. Once one brings in that, especially the mere agreement for release, the whole scheme starts to founder in many cases, not all, but there will be lots of cases, and landlords such as my learned friends' clients will be looking through everything with a fine-tooth comb, trying to find as many of these as they can, and holding it up against right to manage companies. Now, it may not make so much difference if you're with me on the other issue as to the consequences, but if you're not with me, this makes a very important difference for right to manage companies as to whether they can effectively exercise their rights. Unless there's any questions, I think I've actually finished a bit early, so hopefully we can finish by 5:15.
Mr. Deacon. I don't detect any more questions, and that's very clear. Thank you very much.
Thank you.
Yeah, thank you very much.
Mr. Bates.
I'll reply briefly on the appeal and then make a handful of points on the respondent's notice before handing over to Ms. Gibson. Replying on the appeal, there seems to be a degree of common ground being reached that section 79(2) is indeed a consequence. There was a brief discussion between you, my lord, and my learned friend about the 7 days point, would that be invalid or not? And I think my learned friend said that short notice would give rise to invalidity, but not giving notice at all would not. I'm not sure how that can be right. But I think the real point is, as it's coming out in oral argument, is whether or not the 79(2) point is open to me. Is there actually a restriction in the statute that prevents a landlord from relying upon a section 78(1) failure? To put it another way, I think my learned friend did, is it right that only qualifying tenants can take this point? And is it right that they can only take it in the High Court, whether by declaration or by judicial review? Now, can we just take a step back and remind ourselves what happened in A1? Because that's where the Supreme Court introduced this idea of going off to the High Court to have your rights vindicated. The reason that remedy was needed in A1 was because there was no other forum for rights to be vindicated. In A1, what has happened is an intermediate landlord has not been given a claim notice. And if you don't receive a claim notice, you can't give a counter notice. And it's the counter notice that triggers the FTT's jurisdiction. So of course their lordships had to find some way of enabling this particular scenario to result in a method by which people's rights could be determined. But you don't need to be that creative or force people down the High Court route here, because there is a forum by which this point can be ventilated, and that forum is the FTT. Can we go to page 29 behind tab 1 of the authorities bundle?
Sorry, page...
Page 29.
Yeah.
Section 84, encounter notices. 84.2b. This is what everyone's been calling the negative counter notice. So it's a notice containing a statement alleging that, by reason of a specified provision of this chapter, the RTM company was not on that date so entitled. So I can, on the face of it, I can give a notice that says, by reason of section 79.2, you are not entitled to acquire the right to manage. If I do that, it's that notice that then triggers the procedure that ends up in the FTT. Because 84.3 tells us that the right for the RTM company to apply to the tribunal is only triggered where you've been given one or more counter notices containing a statement as is mentioned in 2b. And then 84.4 tells us when you've got to make the application to the tribunal by. So we don't need to create this, in my submission, difficult and expensive route of going to the High Court. I put in my counter notice that section 79.2 is the reason why you can't do it, and at that stage the tribunal can rule upon it. My learned friend, I think, seemed to suggest that there'd be a difficulty with that, because if your case is it's not a valid claim notice, you can't give a counter notice to it. But that can't be right. People give statutory notices in response to statutory notices all the time, saying, my primary case is, your notice is not a statutory notice. It fails for this reason, this reason, this reason. And the tribunal obviously has jurisdiction to decide that, either because we're told it does, or simply because all tribunals, even inferior tribunals, have jurisdiction to decide whether their jurisdiction is engaged. Secondly, saying, as my learned friend did, that this is a point, this section 79.2 point, is only one that's capable of being taken by a tenant in the High Court, fails to engage in my submission with section 71, if you go back to page 4 of the authorities bundle. (71.1) tells us that the acquisition and exercise is by a company in accordance with this chapter. The rights are to be acquired and exercised and subject to and in accordance with this chapter. The reason the Supreme Court had to go outside of the Act and go to the High Court is because something had gone wrong with the scheme and there wasn't a route for having it resolved under this chapter. But there is a route for having it resolved under this chapter here, which is go to the tribunal.
I mean, that's not a route available to a tenant.
It's not a route available to a tenant. I agree. But I'm responding here to the argument that I can't take the point.
Yes.
And I said that for that just simply can't be right. Perhaps another way of putting the same point, if we go back to section 84, page 29 of the authorities, what the effect of my learned friend's argument is that we're going to have to read some words into 84.2b. We're going to have to read in something after, by reason of a specified provision of this chapter, something like, open brackets, quote, being a provision which directly affects the giver of the counter notice. Because what he's actually saying is that unqualified statement of, I can explain why you don't qualify by reference to any provision of this chapter, doesn't mean that. I actually have to explain why you don't qualify by virtue of a provision that directly affects me. That is, respectfully, a lot of reading in to solve a problem that simply doesn't arise if we approach this case in what we say is the straightforward and simple way. Section 79.2 is the consequence. That's what happens. And if Parliament doesn't like that, it can change the law. And the final point I make in reply is that, as I was sure he would, my own friend took you through all the policy provisions driving the thinking, the background of this Act. I simply repeat what I said earlier, which I don't think my own friend engaged with. That can't. That's the Seneti question. That's the, when Parliament hasn't specified a consequence, what do we do about it? But Parliament has specified the consequence. Turning then to the respondent's notice, and a handful of points I want to make before handing over to Ms Gibson to deal with the meat of equitable tenancies. The first is a point I made in opening about just how narrow the issue here is, because my learned friend, as he's perfectly entitled to do, presents this as creating all manner of difficulties for RTM companies, all manner of pitfalls into which companies may fall. Judge Cooke, I venture to suggest, probably knows more about property law than certainly my learned friend or I. I'm certainly prepared to accept she knows more about it than I do. She can think of only two scenarios where this is actually going to arise. First is, as in this case, first grant of a lease, effectively first sale, out of registered land. And the second is grant of a lease out of unregistered land. This is not some general trap that's being created. It's a specific problem for two relatively rare scenarios. I accept first registration on first sale will be more common than grant of out of unregistered land. But this isn't some problem that's going to be bedeviling blocks of flats up and down the country for centuries after leases are granted. And that's important. The narrowness of that context is critical. Because, as we've already noted, there's a disagreement between us here about what the policy of the Act leads to. I say it promotes equitable leaseholders. Why should they be excluded? But my learned friend's answer to that respect can't be right. My learned friend said it promotes the interests of leaseholders to exclude equitable leaseholders because that benefits the legal leaseholders. That was his last point to you he was making to you. That's the simplicity. But that's not right on Judge Cooke's analysis. If there's a legal leaseholder, that person's always the qualifying tenant. And I haven't challenged that. It's only where there is no legal leaseholder. And so what he has to grapple with, and in my submission he hasn't grappled with, is why should that leaseholder, who to all intents and purposes is the owner in every meaningful sense of their property, why should they not have all the same rights? Why should their right be different to their neighbours simply depending upon the workload of the land registry? We need, in my submission, when dealing with my learned friend's respondent's notice, to be clear about what the precise objection is, although they both lead to the same conclusion. The objection can't be, in my submission, to the fact that the equitable lease is unregistered, because on any view, there are leases that qualify on the face of the statute and which could be unregistered. For your references, I won't take you to it because I'm conscious of the time, but Upper Tribunal's judgment, page 67, paragraph 32, is a submission of mine about a lease that could be unregistered. My learned friend in oral argument put to you a short shared ownership lease could be unregistered. Judge Cooke's paragraph 64 at page 72, it seems to me she's accepting that there will be unregistered leases that fall within the definition of long lease. So it can't be registration. It also can't be the difficulty of discoverability. Because as Judge Cooke explains correctly in my submission, there are long leases that fall within the definition in section 75 and 76, sorry, 76 and 77, which will be hard to discover. And she gives some examples again in her paragraph 64. The obvious one is on death. Unless you know that your neighbour has died, you won't know there's been the vesting. So it's not registration, and it's not discoverability. So then what is the objection? If you strip away those two, the objection comes down to, it leads to a result he doesn't like in this case. That's a perfectly proper thing to argue for, but it's not a principled objection to why Judge Cooke is wrong in the very narrow circumstances that she's identified. There's no inconsistency, despite what my learned friend says, with A1 here. As Judge Cooke notes, again, for your references, we won't go there, put one eye on the time, it's her paragraph 65. The Supreme Court in A1 don't say that invariably the qualifying tenant will be the registered interest. They say ordinarily. I'd agree with that. Mr. Justice Fancourt said exactly the same in Canary Gateway case. The vast majority of the qualifying tenants are going to be Section 76(2)A people. They've got normal, long leases for more than 21 years, and the vast majority are going to be registered. But that doesn't help us with why other people who fall within the definition should nonetheless be excluded. Two other short points before I hand over to Ms. Gibson. The first, and I won't do it now because pressure of time, but I mentioned in opening the appeal that there were written submissions after A1 came out. Just for your completeness, I'd asked you to draw, when you come to make your decision, to look in particular at what we say at paragraphs 6 to 15, which is page 144 to 146 of the supplementary bundle.
Should we just turn that
Of
up,
course,
at least to
yes.
identify it?
Sorry, could you just give me the paragraph number?
In the supplementary bundle, it's paragraphs 6 to 15 at pages 144 to 146.
Thank you.
I say that, we better just check those are the right references. Ah, yes, there we are. Yeah. A lot of what my learned friend said to you in oral submissions, we address there, as we addressed them before Judge Cooke. I rely upon those in the same way. And the final point I wanted to make before handing over to Ms. Gibson is an answer to my learned friend's concern about simplicity. I've never really understood why service of a notice inviting participation is so difficult. Can we just look at page 67 of the authorities, tab 1. It's 1115, which was the provision that was being considered in the Regent's Court case. A company which is an RTM company in relation to premises may give a notice under this chapter to a person who is the qualifying tenant of a flat contained in the premises at the flat, unless it has been notified to by the qualifying tenant of a different address. So what actually stops RTM companies just getting their claim notice, that their NIPs, saying, dear qualifying tenant, pushing it through the front door of each flat? And that meets section 1115. The only way it wouldn't is if they told you of another address, but then, logically, you know the qualifying tenant is somewhere else. So you know there's a qualifying tenant of that property as well. The only answer I've ever had to that question, and as you might imagine, my learned friend and I've debated this in numerous cases up and down this country, is that the prescribed form of NIP does appear to suggest that you're supposed to name the tenant. But that's not what the Act says. Nothing in Section 78 requires you to name the qualifying tenant. And we know from decisions of this court, I'm thinking of something like O.G. Thomas, the recent notice to quit one. Notices to quit are good if just served on the tenant. You don't have to name the tenant. We know in the particular context of residential leasehold service charges, we know that consultation notices inviting the leaseholders to make their observations are good if they're just served upon the tenant or the tenant for the time being. I don't, for my part, understand why 1115 isn't the simplicity answer. You just put it through the front door of every flat. And either that's good, or you've been told beforehand that there's some other address for the qualifying tenant, so you know all you need to know about them anyway, which is how to find them. That is how you get the simple answer that Parliament wanted. It's not by trying to exclude some category of otherwise qualifying leaseholder.
Sorry, could you just remind me of the section number? Was it 111?
111 sub 5.
Thank you. Yeah.
Now, there is quite a bit for Ms Gibson to deal with on why Judge Cooke is right that equitable tenants are included, but I'll hand over to her for that if I may.
Ms Gibson.
You can have that too.
My lords, the remainder of our case, along with hopefully what's gone before, is very straightforward. Judge Cooke is right for the reasons she gave, and some other reasons for good measure. A central complaint of the respondent on the RN, as summarised in his skeleton, you don't need to turn to it, but it's paragraph 26 on page 41 of the core bundle, is that the judge must have erred because to decide that Ms O'Connor is a qualifying tenant is inconsistent with 4 major points. First, Avon properties. Second, long-standing principles of property law, property statutes, and everything else concerning the differences between legal and equitable ownership. Third, it's inconsistent with the 2002 Act more generally, including section 1122, as well as the 7 Sunny Gardens decision that I'll take you to later. And fourth, the Prince of Wales Road case, that despite the submissions of myself and Mr Bates to the contrary, a landlord within the Act refers to the legal, not equitable owner, where there is a pre-existing legal interest which has been assigned but not yet completed by registration. Mr Bates has already addressed on how we say we're not inconsistent with Avon properties, so I shan't be addressing that, but I will be addressing the other 3 inconsistencies and saying that they're not actually. She's right. So then the best place to start is section 1122 itself, on page 70 of the authorities bundle. Being that in this chapter, lease and tenancy have the same meaning, and both expressions include where the context permits an agreement for a lease or tenancy. So the long and short of this is that we say, as Judge Cooke said, that section 75.2 long lease can include per section 1122 long equitable lease because section 1122 allows an agreement for a lease being an equitable lease or motion Lancel to be included. And it would be unnecessarily complex to separate that from our lease. Now we accept we haven't got an agreement for a lease. It's just a lease in the gap. But we say that that doesn't matter, not least because of the term where the context permits. Now I say that where the context permits can do at least 2 things. It can include as a lease an agreement for a lease, which is an equitable lease, where the context permits. And likewise, it can exclude an agreement for a lease or an equitable lease. But by virtue of saying they include an agreement for a lease, A42 or as Judge Cooke said, it's got to include our lease as well, in principle, and where the context permits. And part of the reason for that is because of the status of Miss O'Connor during that gap. Now, this gap was very clearly explained by Judge Cooke herself in RM Residential. If we can turn to tab 23 of our bundle. Now, the facts have been addressed, so I shan't be going into those. But the absolutely crucial point in this case arises from, we say, paragraphs 39 to 41 and 42 on page 403 of the bundle. Particularly paragraph 39. During the gap, the vendor holds a legal title on a bear trust for the purchaser. As a bear trustee, the vendor has no power to make decisions about the property and must act at the direction of the purchaser. So that is one way of conceiving the nature of the equitable interest. There are other ways of conceiving of that, and for completeness, they are addressed in McGarry and Wade. I think it's the chapter 6, paragraph 53 within that, which is in the bundle. We needn't turn to it, but it's just in case the academic interest strikes.
We don't want to go too far into the academic rabbit holes, do we? Because of the
Precisely.
suggestion there might be some room for argument about the precise nature of the equitable interest.
Which is why we need to look to the practical reality of the person in that gap, like Miss O'Connor. Being the crucial point made by Judge Cooke in this case, RM, and in our case. Particularly then, paragraph 41. The practical effect of that is well known, being when one is in that gap. It's well known to anyone who's bought a house and to the conveyancers. On completion day, the transfer is signed and dated, the keys are handed over, and the purchaser moves. The property belongs in equity to the purchaser, and to say that at that stage is not the owner of the property both flies in the face of everyday reality and betrays a failure to understand equitable ownership. True, there are just a few things the equitable owner cannot do in that gap, such as giving a notice to quit, but entering the property is not one of them. So then, this concept of flying in the face of reality and not understanding the true nature of equitable ownership, that's Miss O'Connor. She was aware of the RTM company. And if we look to paragraph 28 of the Upper Tribunal's decision on page 66 of the core bundle.
Sorry, which decision being the Upper Tribunal?
Yes, the core bundle, page 66. Now, paragraph 28. This explains the wrinkle as alighted upon by my lord earlier. Particularly, I'm interested in the second half of the paragraph. So it became known that Miss O'Connor existed, her mother rented the flat for many years, and that she and her mother were known to Miss Bellamy. When she came back to live there, this is Miss O'Connor, after her mother's death, she contacted Miss Bellamy to ask if there was a residents' association, and then mentioned that she now owned the flat. She attended Zoom meetings held there, held to access support for the bid to acquire the right to manage, and was supportive of the process, but was waiting until Lisa's registered before becoming a member of the company. So she, notwithstanding her recognition there, that she couldn't join perhaps until it all gone through, but she considered that she owned the property. She was taking part in this process. And so we say it would fly in the face of reality if Miss O'Connor were not to qualify here. Particularly this appeal to Judge Cooke in her paragraph 55 on page 71 of the core bundle. And here we get back to the point about, does section 1122 exclude non-Walsh and Lonsdale leases, or can it include all equitable leases where the context permits? And the idea that certain equitable leases, namely the ones that cannot readily be regarded as agreements, are excluded from the ambit of section 75.2 would make that section incomprehensible to all but the most specialist of property lawyers and would open up vast areas of sterile debate. I think it's quite interesting, but I appreciate that that's not the aim of the statute. But it would be impossible to understand the reason for such a distinction. Put another way, if a lease in section 75.2 includes an agreement for a lease or tenancy, then a fortiori it must include equitable leases. So in this case then, the judge accepted the submissions I put to her also, in the Upper Tribunal. It's absolutely trite law that an agreement for a lease is an equitable lease, and there it makes no sense when one takes into account particularly the context and the purpose and the rights imbued upon these qualifying tenants if one is excluded by virtue of the land registry delays. When there is a section we have here, 1122, which allows the court to interpret the section in such a way that Ms. O'Connor is included. But yes, we completely accept that there are limits in general on what an equitable owner in this gap can do, particularly as alighted upon by Judge Cooke in our own residential at paragraph 41, giving an NTQ. Now, in my submission, there is no difference, and it's inconsequential that Miss O'Connor could not serve a notice to quit, imagining that the statute would arise to put her in that position. That she cannot serve an NTQ does not preclude her from being able to be within this scheme, because section 1122 allows her to do that. And a notice to quit is a different beast to being a qualifying tenant under the 2002 Act, which doesn't change ownership. It doesn't affect a change in who owns the building, it just simply transfers management functions. And so in this context, that certain abilities are not open to Ms. O'Connor does not preclude this one. And this takes us also to the points made against our paragraph 17 in our skeleton. Perhaps turn to that for ease. It's on page 54 of the core bundle. In this paragraph, as accurately outlined by my learned friend, we state that there are other powers, rights, abilities that equitable owners have. For instance, 17A, an equitable business tenancy is within Part 2 of the 54 Act. They can apply for relief from forfeiture. They have these owners' powers, which, including in section 23, you needn't turn to it, but I'll give you the page reference in the authorities bundle. It's on page 74. Even includes the power to charge the estate with a legal mortgage. So someone in the registration gap can have a legal charge over the registered estate despite not being legal title holder. And then there's also the scribe's case there. And our point is not that because other statutes have certain language allowing certain equitable owners under those statutes to have certain rights, therefore necessarily our tenant under this statute must have these rights. Our point is a much more general one. That it is not inconsistent for an equitable owner to have an ability. If the complaint is that we shouldn't allow Miss O'Connor to qualify because that's an inroad into legal ownership, then the ship's already sailed. Equitable owners already have certain abilities. And when there is a principled case and a section 1122 which allows you to interpret section 75.2 in such a way as to bring this person within that section and within this scheme, then we should do that. And it's not a surprise, therefore, that Judge Cooke chose, when reading and properly interpreting this statute and the facts, to add another string to the equitable bow. There's already a realm of rights there that's available. And another point raised by my learned friend is the case of 7 Sunny Gardens in the Upper Tribunal. Now, this is mentioned in his paragraph 26.4, again on page 42 of the core bundle. It's said against us that our finding and Judge Cooke's decision below is inconsistent with the dictum from there, which I'll take us to later, being that the 2002 Act is not concerned with beneficial interests. Now, in summary, I will get us to the point where that quote needs to be read in context. And there is absolutely nothing inconsistent in Judge Cooke's judgment with that decision, and in fact, it's entirely consistent for the reason she gives and more. If we could please turn to tab 11, the authorities bundle. Quickly on page 186. So it's a decision of Martin Roger QC, Deputy President. And I must first caveat, of course, this is not binding on us here. And in any event, it's a very peculiar decision on very bizarre facts, which I hope to explain now. So then, in paragraph 6 and 7, well, we learn about the facts in this section of the judgment. Now, this case concerned Mrs. Foskett. And we see that in paragraph 7, the 3 leaseholders being Mrs. Foskett and, as at 6, her neighbours, Mr. Gould and Mr. Wilby, decided to take steps to acquire the RTM. They were advised and represented by a company purporting to specialise in RTM applications. So the formation of the RTM company was resolved, and each of the 3 leaseholders agreed to become a director and shareholder. So this is July 2011. We flip to paragraph 8. We read that on 20th of September 2011, before any formal steps to bring the project to fruition had been completed, Mrs. Foskett died. And it was not known whether she left a will or when or whether probate had ever been granted of her estate. Paragraph 9. The company advising the leaseholders was not yet aware of her death, when 7 months later it took the steps necessary to incorporate the respondent. It appears that all the relevant documents were signed by Mrs. Foskett before her death, and these documents are dated 23rd of April 2012, notwithstanding that I believe it was 7 months prior Mrs. Foskett had died. So there's an oddity there about these documents. But putting that to one side for the moment. The claim notice was served, and then asset hold somewhat characteristically served a negative counter notice, and then there was a section 84.3 determination. Now we have at paragraph 16, and one of the points that was taken was that the notice in writing participation should have been served upon Mrs. Foskett's personal representative, who would have been, upon her death, the qualifying tenant of her legal registered lease. But the RTM company was alleging that actually the qualifying tenant was Mrs. Foskett, despite her death. And then at paragraph 16, the Upper Tribunal details the LBT's explanation for why it held that Mrs. Foskett was a qualifying tenant. It relied upon Brown and Root, the classic registration gap decision, which is later on explained in the Upper Tribunal's judgment, so I'll come to that later. So essentially saying that because there hadn't been any transfer under the lease, there's been no registration of that of any transfer. It meant necessarily that Mrs. Foskett was the qualifying tenant. And then we come to the Upper Tribunal's own decision. Paragraph 24 details the Administration of Estates Act 1925 makes provision for devolution of real property on death. So far as relevant, section 1 provides as follows. It devolves on the personal representatives of the deceased. And then by section 9.1 of the Act, it's provided that if a person dies intestate, his real and personal estate shall vest in the public trustees until administration. And then you get to paragraph 26, which discusses the section 27 of the Land Registration Act. And quotes the same so far as material. So certain dispositions must be registered if they are to take effect at law, not merely in equity. But there's an important exception to that principle, relevant to this appeal. Section 27 provides so far as relevant as follows. Now you have section 27.5 being the material provision here. This section applies to dispositions by operation of law as it applies to other dispositions, but with the exception of the following. A transfer on the death or bankruptcy of an individual proprietor. Hence, there was no need for anything to be completed by registration here. It happened automatically, notwithstanding the register would have given you no idea about that at all. And the effect of these sections I've just mentioned is explained in paragraph 28 of the judgment, the combined effect of the 1925 Act. The disposition took effect by operation of law without the need for any transfer and critically without the need for registration. And then we come to paragraph 29 being the one relied upon by my learned friend. To be the qualifying tenant of a flat, a person must be a tenant of that flat. The tenant referred to in section 75.1 of the 2002 Act is a person in whom, for the time being, the legal estate created by the lease is vested. I'm pausing there. That's what Judge Cooke said. If there is a legal lease, then they're the qualifying tenant. That's the end of it. Then you have the second sentence. As the LVT correctly observed, the 2002 Act is not concerned with beneficial interests. At the relevant time, the qualifying tenants of the flat 7A were therefore Mrs. Foskett's personal representatives. And then the conclusion to this point comes on at paragraph 35, over leaf, on page 193. It was held then that the claim failed because the RTM company failed to serve the notice inviting participation on the personal representatives who were the qualifying tenants, notwithstanding that the need to serve them rather than Mrs. Foskett wasn't apparent from the register, and notwithstanding the fact that the RTM company apparently didn't even know that she died, and so couldn't have known that they need to serve the personal representatives. And consequently, the failure to serve the notice inviting participation on the legal tenant, even though they were not discoverable on those facts, was fatal. And the point is taken against us. I'm a learner friend here. The point was taken against us in the Court of Appeal in Prince of Wales Road then. This one sentence from this judgment, the 2002 Act is not concerned with beneficial interest. This has been taken to mean, respectfully, that equity is irrelevant entirely in this context. But that can't be right because of section 1122. And for the reasons given by Judge Cooke, she properly appreciates the importance of viewing this in context and how it can't be authority for this broader proposition. And this is in her paragraph 60 on page 72 of the core bundle.
I mean, in a particular case, my recollection is that where you have an unadministered estate, you don't get a trust anyway in the conventional sense, so you'd find it hard to find a beneficial interest. But anyway, that's by the by.
Yes, and precisely because there was no beneficial interest in this case for which they should have been concerned, taking this dictum out of context and giving it more meaning than perhaps it might have meant in that moment, given the facts of that case, is, in my submission, misconstruing what this case is in fact authority for, even if it were binding upon us today.
In any event, the express inclusion of agreements for release in section 112, subsection 2,
Yes.
shows beyond possibility of argument that equitable interests are potentially involved, because if that's a specifically enforceable contract, you have an equitable interest.
Yes, and I believe that my learned leader was involved in this case, so you might know more, but I don't think that section 112 was brought to Martin Rogers' attention in this case. So perhaps if it had been, there might be a different conclusion. Don't know. But never mind. And then back to Judge Cooke's analysis of 7 Sunny Gardens. So her paragraph 59 on page 72, just for good measure, outlines that when there's both a legal lease and an equitable lease, the context does not permit the equitable lessee to be the qualifying tenant. In those circumstances, the qualifying tenant is the legal lease. And then, perhaps because it was another decision of the Upper Tribunal, explains how in paragraph 60, that is consistent with the analysis in 7 Sunny Gardens, where there was a legal lessee and therefore there was no need and no opportunity for the tribunal to consider the position of an equitable owner of the lease, nor to inquire whether there was one. In such a case, as the Deputy President said, the 2002 Act is not concerned with beneficial interests. And then there's the issue of Prince of Wales Road, which I say is not really an issue. For those purposes then, we can please turn to tab 8 in the bundle. Beginning on materially page 111. So while my learner friend, Mr. Jacob, he did take you through the facts of the case, and there was nothing incorrect about how he described the facts, but I think something else just needs to be alighted on for completeness, or should just made start. First, in this case, it was an assignment of a pre-existing legal interest being an issue. So there was already a legal title holder that was not our client. So we were submitting that we were a landlord under a lease in that gap when there was a pre-existing legal owner, which wasn't us. Whereas in our case before you today, that's not so. There's only Miss O'Connor. There's only an equitable title holder. And then another point, just I think for the sake of clarity. Now, on our case, Asset Hold had in October 2019 purchased from 2 companies the freehold and the head lease. Now, I say on our case was because there was some factual uncertainty concerning whether on the evidence there was enough to satisfy the court that these purchases had in fact occurred, either on that date or at all. We needn't turn to it, but for reference, this uncertainty is recorded in paragraph 21 on page 115 and 58 in 122. Nothing seemed to turn on that because of the reasons that the judges gave, but that's just another factual difference with ours. as well as the section that we were seeking to rely upon, being, in that instance, section 88 on page 113, quoted in paragraph 13 of the judgment. So the reason that asset hold was relying upon being a landlord under a lease in that gap is to take advantage of section 88(1)(a), the cost provisions, which are now repealed, at least in so far as this section is concerned. And that relied upon the submission that we were a landlord under a lease. Notwithstanding that we were a landlord in the registration gap, which wasn't a party to any lease, we were simply being assigned pre-existing interests. And yes, my learned friend took us to paragraph 27 on page 116 and paragraph 28, where the court didn't accept our submissions that asset hold was indeed a landlord under release in this gap. Then at 29, we have the 7 Sunny Gardens, the quote. Then turning to paragraphs 31 onwards, so page 117. So this explains why we prayed in aid of section 112 in that case as well, but nevertheless were unsuccessful. Now, section 1122 provides for a specific extension of the concept of a lease to include where the context permits an agreement for a lease. But nothing is said there that indicates that agreements to transfer existing interests may have the effect of treating the transferee as a landlord, either in place of or in addition to the transferor. That is so, irrespective of whether such an agreement has been completed by an unregistered transfer. And then further at paragraphs 32 to 35, in the interest of time, I would invite my lawyers to read them after this hearing, but they address the importance of the language landlord under release in section 88(1) and why asset hold didn't qualify, being a difference of considerable note to our case today. And then if we may turn to paragraph 41 on page 119. Here the court outlines my submissions that I made on Cresta Court. In essence, I submitted similar to how I've submitted today. And I did those same submissions, or simply slightly different, to the Court of Appeal. But then I didn't address to the Court of Appeal why it should be different treatment for a tenant, because I didn't need to. It wasn't the case before us. And then the court at 41 explains the submissions, explains the facts of Cresta Court. At 42 records that as the UT held, at the relevant time no legal lease was in existence. Rather, Miss O'Connor held an equitable lease. The UT concluded that this was sufficient to require notice to Miss O'Connor, albeit A1, it was not invalid. Now, Cresta Court is clearly distinguishable. The UT relied on the specific inclusion of agreements for lease in section 1122B and reasoned that because agreements for lease are equitable leases, if specific performance would be available, it would be incomprehensible if other forms of equitable lease were also not included. The UT's conclusion therefore related to A, an interest in land which existed only in equity, and B, in the context of a specific provision for an agreement for lease. In contrast, in this case there are existing legal interests that were vested in Millcastle. And there is no equivalent to section 1122B that applies to agreements to transfer them. The court heard submissions on Cresta Court from both the appellant and the respondent in that case. It chose to distinguish Cresta Court. Rather than say it was wrongly decided, it would have been open to it. It wasn't bound by it. But in my submission, you should read 42 and 43 as implied approval of Judge Cooke's decision. So that's one way of saying that Prince of Wales Road actually supports our case. But then there's many other reasons for that as well. First, there's the similarity with it being the legal title holder, if one exists, being the material individual. That's what the Court of Appeal held then, that's what Judge Cooke held. And Mr. Bates has already addressed, my lords, on the importance of qualifying tenant status for these individuals, and has already explained how the Upper Tribunal decided that this outweighed any counter mischief of excluding them and depriving them of this status. And that's at paragraph 68 to 73 of the core bundle of reference. Now, those policy considerations aren't present in Prince of Wales Road, rather the opposite, one may say. So Miss O'Connor is in a totally different position to asset hold. So we say that simply saying that the Court of Appeal considered that it was the legal landlord that was always be the one that was important doesn't mean, as in our case, that an equitable tenant where there is no legal title holder should be missed out from this process. And furthermore, paragraphs 47 and 48. This might be a particular reflection of the realities of the landlord versus the role of the power of the tenant. Because as alighted upon by the court at 47, we've submitted that because asset holder is heavily involved in the building, it should be able to investigate, should be able to recover its cost for doing so. But the court didn't consider that the natural construction of landlord was outweighed by our role in managing the property. It's open to a buyer in asset hold's position to mitigate the potential risks by ensuring that terms of its acquisition make appropriate provision for the seller to pass on notices or take other steps in relation to leases, including acting as the buyer directs following completion and prior to registration. A properly drafted provision of that nature would not only have required Milcastle to pass on any claim notice, but would have permitted asset hold to instruct Milcastle how to respond to it and to take other steps on its behalf. And so to skip to the end of 48, the solution for buyers in the position of asset hold lies in their own hands. Those considerations just don't apply here. There is no legal title holder in respect of Miss O'Connor's lease who could take those steps for her benefit for when she decides, or for when the registry gets round to registering her lease. She's entirely on her own. You cannot say because the court said about landlords it must therefore be the same for tenants. Unless I can help you further, I think that concludes our submissions on the RN. And
I don't detect any more questions, so thank you very much.
Thank
Thank you.
Mr. Jacob.
Yes. Just 2 points I'd like to come back on. So, one point was in relation to Mr. Bates' argument saying, well, let's try and specify what is the objection taken to allowing equitable lessees such as Mr. O'Connor being a qualifying tenant. And he said, well, it can't be non-discoverability. I reject that. I'd say it can be non-discoverability. Judge Cooke envisaged that in one set of circumstances, core bundle 72, paragraph 58 of her judgment. That's where she talked about the right of acquisition being well nigh impossible if we unadopted the construction that was originally suggested, or it's always the equitable tenant, even if there's a legal one. And she says unregistered purchase of flats are pretty much undiscoverable unless the legal lessee chooses to disclose their existence. And then she talks about matter of routine, section 82 inquiries of everyone. Well, there's still an issue, a similar issue with discoverability of equitable lessees or those with agreements for leases of flats which currently have no legal lessee. Maybe not as extensive perhaps, but it's still the same issue of undiscoverability which arises. And I say that's still going to create problems and tripwires for the unwary, and it's against the tenor of the reasoning of both the Supreme Court in A1 Properties and Mr Justice Fancourt in Canary Gateway in the Upper Tribunal, relying on the fact that qualifying tenants should be quite easy to find because they're on the register, which is what is the underlying assumption of lots of previous analysis of this. They're on the register because they're all over 21 years. It's not about, oh, there could be off-register ones that you have to be looking for. And the Supreme Court saying, well, that maybe explains why there's no dispensation provision for NIPs, because it's easy to find. So this is very much a problem, the discoverability problem, and it won't be as large as if you just went with equitable tenants, but it's still there and it still supports my submission. The second point is a little issue that Mr Bates chucked in at the end about why is it so difficult to serve NIPs in the first place? Why can't you just post them under the door? Now, this is something that was chucked in the Upper Tribunal as well. I have some notes from the Upper Tribunal where I dealt with it, and I've just been looking through my notes there again to see how I responded. I've realised that some of the provisions I referred to are not in your authorities bundle, they're only in the Upper Tribunal's authorities bundle. So I'm just going to run through our side of the argument, but I may need to refer you to things that you don't have before you. So the starting point is I say that would not comply with the statutory requirements, just to put to the qualifying tenant. I start with section 78 of the Act, which you do have, so in tab 1, page 17. So 78.3, subsection 3 on page 17. Statute says a notice of invitation to participate must also comply with such requirements, if any, about the form of notice of invitation to participate as may be prescribed by regulations so made. The starting point is to direct you must comply with the form. There's no saving provision either there or in the regulations which says the notice can be substantially to the same effect, as you often see in various statutory provisions, but it doesn't appear here. The regulations are the 2010 regulations. I took you to part of them, tab 3 of the bundle earlier, but we've only put in the bits relating to claim notices. So this is where I have to go a bit off bundle. But going to the Upper Tribunal bundle, which I have on my computer. So Regulation 8 deals with form of notices, its title. 1. Notices of invitation to participate shall be in the form set out in Schedule 1 to these regulations. Schedule 1 then has a form of notice, similar sort of setup to what you'll see on page 91 of the bundle, where it's got Schedule 2, the form of the claim notice, and it has an example. Similar with Schedule 1 has a form of notice of invitation to participate. And as my learned friend referred to, it has the addressee part of it, so it says to square bracket, name and address, close square bracket. See note 1 below. Note 1 says the notice inviting participation must be sent to each person who is at the time the notice is given a qualifying tenant of a flat in the premises, but who is not already or has not agreed to become a member of the company. A qualifying tenant is defined in section 75 of the Act, and it takes you back to that. So the form could have simply said to the qualifying tenant, but it says to name and address. So it presupposes the name is known as well as the address. So in my submission, the natural reading of that is you do have to name the individual. A lack of a name, so imagine one did just put to the qualifying tenant, that could create problems in receipt because there's no residence requirement, as I mentioned earlier, so you could have a foreign investor who gets this property. A letter just turns up saying to the qualifying tenant without their name and address on it. Maybe there's a subtenant on an AST in there, somebody gets this thing saying to the qualifying tenant, I don't know what that means, throws it away. If it has at least the name of the individual who actually is a tenant, you may have some chance of it getting to them if they don't actually live there. But if it just says to the qualifying tenant, it's probably less likely it will achieve its purpose of getting to the right person. If there's a redirection service, if their name's on it, it might be redirected. If it says qualifying tenant, it probably won't be. So it doesn't appear to be in accordance with this scheme. If right to manage companies tried doing this, one can imagine their friends' clients raising this, saying, excuse me, this is not in accordance with this. So they would raise the opposite argument. They would run with what I've just described as, well, it says name and address, so surely you have to put the name. You can't just put the qualifying tenant. So that would be an objection that would be raised. The final point I said to Judge Cooke, which I'll say to your lordships, was if you wish to say, actually, all you need to do is say the qualifying tenant and put it under all the doors, it may not help us in this case, but it'd probably be very helpful for all future right to manage cases. And I said to her, if you want to go down that route, okay, well, you tell us that I'm wrong and give us that get out clause in future. She chose to ignore that and didn't mention it at all in her judgment, as far as I can see. But I'll just say exactly what I said to her. So I'll leave it with your lordships, but it does seem likely that the name and address is required. And I have nothing else unless you have any questions.
No, thank you very much. Mr. Bates, strictly, I think you must have a right to reply on the new elements of the regulations that we have been referred to.
I don't want to make this any more difficult than it needs to be. And also, I'm aware my learned friend and I are in danger of descending into private debates.
We're getting quite a long way from the real issue.
Well, quite. But I think the simple point was, my learned friend is right because he has very strong Supreme Court authority. This is supposed to be kept as simple as possible. My answer is simply, in a whole range of other sections, of other property statutes, we know you're allowed to just send it to the tenant. I really, for the life of me, don't understand why this is any different. I'm sure landlords will disagree, but in terms of trying to meet what is his legitimate point is that if you're presented with two submissions, one that makes this very complicated and one that makes it very simple, you are to be driven down, and you have a choice, then there is ample guidance that you should go down the very simple route. I'm simply saying I don't see why that isn't a very simple answer. But for my part, I don't think that's where this appeal rises or falls. It comes back to what does section 79.2 mean, who can take the point, and are equitable tenancies where there's no legal interest included? And the answer to that isn't governed by
this debate.
A footnote to a regulation in an SI.
No. Well, thank all three of you who've had speaking roles very much for very clear submissions. Thank others too who contributed to all this. We're not, of course, going to give judgment here and now. You'll receive the draft in due course for you to correct our English and typing, but not so as to re-argue the case. We'd be grateful if at that stage you'd also seek to agree an order dealing with consequential matters. If there are points on which you disagree, could we please have brief written submissions, and we'd expect to settle the points in the order that we make. And finally, though you all have heard this many times before, I should remind you of the importance of the embargo. If you think of anybody who we don't know about already who ought to receive the draft, you obviously need to come back to us rather than just giving it to them. But thank you very much.